Aguilar habla inglés.
Yes, he does.
Good morning, sir. You were arrested for one count of second-degree murder. It says with a weapon and possession of a firearm, weapon, or ammunition by a convicted felon. I will appoint the public defender's office for you.
We'll be invoking Mr. Aguilar's right to counsel and his right to remain silent.
Thank you. So this is a case from July 12th of 2025. It happened at the North Side Shopping Center where the victim was shot multiple times. I guess the victim was having a romantic affair with the defendant's wife. So I guess he approached the victim, produced a firearm, and shot the victim multiple times and killed him. The victim drove a short distance before becoming unresponsive and stopping at the final resting place. They recovered a Glock 26 9mm handgun from the defendant with two spent casings. Two 9mm spent casings and one projectile were recovered from the victim's vehicle. The incident location. So he says he was engaged in a heated argument with the victim who was inside the driver's seat. Victim reached down in the vehicle as if to retrieve a firearm, so the defendant shot him multiple times in fear of his life. So that's the allegations. Defendant is also a convicted felon and should not have had a gun. There is probable cause.
I would ask you if I know probable cause. According to the police report, Mr. Aguilar told the police that the alleged victim was reaching down. He thought he was going to be shot. Interestingly enough, the police do state that they did recover a firearm from the alleged victim's car, not to, it just looks like on June the 5th. So it appears that he was probably known to be carrying a firearm in his vehicle. So I would ask that you release Mr. Aguilar, Judge. It appears to be a case of self-defense.
Okay, thank you. Ms. Sturgis, would you like to respond?
I would, Judge. There's no evidence here to corroborate what the defendant is alleging to happen. In fact, evidence to the contrary indicates that a search did not reveal a firearm on that day, and that video footage from the incident confirms that there were no individuals entering the vehicle. With respect to a firearm that may have been there on June 5th, that is not relevant to what happened on this date of incident. State's position, there is probable cause for the charges as alleged here, and because of that, we've filed a motion for pretrial detention pursuant to Florida statute 907.4015D, and we would ask the court to hold him no bond and reset this case for division on Monday.
Okay, there's probable cause for second-degree murder with a firearm. I'm granting the state's motion for pretrial detention pending final hearing and holding you with no bond. Count 2, there is probable cause for possession of a firearm by a convicted felon. That bond is going to be $15,000. You'll see a judge on Monday, and that judge will set the final hearing on the state's motion for pretrial detention. Good day, sir. Next, we have Amaris Japa, page 8. Is Mr. Japa eligible for pretrial? Yeah. Although he has 2 priors, we need 1 prior conviction for this. Mr. Japa here? Good morning, sir. You were arrested for driving as a habitual traffic offender. I will appoint the public defender's office for you. Sir, you keep driving without a license. I'll give you pretrial today. You get arrested again, you'll be locked up in jail until your trial. No drive order, no driving unless you have a valid license. Do you understand? Pretrial alternate bond, $2,500. Good day, sir. Next is Daryl Neely, page 8. Who's this one here? Oh, that's for that. Mr. Neely coming in. Line them up quicker. Be good, we get out of here. Good morning, Mr. Neely. You were arrested for possession of cocaine and possession of drug paraphernalia. I will appoint the public defender's office for you. There's probable cause for the charges. Is he eligible for pretrial? Pretrial services, alternate bond, $2,500 count one and 500 count two. Have a nice day, sir. Thank you. Next, Noslen Torres Veolanga, page 9.
Spanish interpreter, please.
Good morning, sir. You were arrested for aggravated battery. It's from June 29th of 2024.
Señor, le han puesto cargos por agresión con agravante y la fecha es el 29 de junio del 2024.
Can you afford to hire a lawyer, sir?
Señor, ¿usted puede contratar su propio abogado, un abogado privado?
Sí.
Yes.
Do you want me to reset this case in the afternoon for you to have a lawyer come to court, to be in court with you, or do you want me to set a bond now without a lawyer?
Señor, ¿usted quiere entonces regresar por la tarde para la audiencia de la fianza en la tarde para que usted pueda llamar a un abogado para que esté presente ahí con usted o quiere que usted fije una fianza ya sin abogado?
Bueno, está bien, sin abogado
¿Cuál
está
de
bien.
las dos quiere? Hábleme en el micrófono, por favor.
Sin abogado está bien.
Without an attorney is fine.
Okay, there's probable cause for aggravated battery. The victims needed stitches and also had a knee fracture.
Entonces hay motivos fundados por la agresión con agravantes. La víctima necesitaba puntos y también tiene una fractura en la rodilla.
So, sir, you are ordered to stay away from the alleged victim, whose initials are IDM.
Señor, le han pedido que se aleje una orden de alejamiento que se aleje de la víctima IDM, los iniciales IDM.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la víctima directamente o indirectamente en persona, por teléfono, por texto, correo electrónico, escrito o a través de terceras personas.
No contact with the victim through social media or other electronic means.
Tampoco puede tener contacto con la víctima por medios sociales ni dispositivos electrónicos.
And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times.
Tiene que mantenerse al menos de a 500 pies de la víctima, casa, escuela, empleo y donde frecuente.
Do you understand the stay away order?
Señor, ¿entiende la orden de alejamiento, sí o no?
Ok.
Ok,
1 second.
¿sí o no?
Sí.
He said
Yes,
sí.
gracias.
All right, I'll set the bond at $7,500. Have a nice day, sir. There's
Le
probably.
voy a poner la fianza en $7,500 y ya puede tomar asiento. Buen día.
Gracias.
Thank you.
Next case is Tony DeFell.
Your Honor, he's gonna be NBC.
Judge will waive his presence.
Appoint the public defender's office, waive his presence. There's probable cause, $2,500 bond. Next up is Conray Heath on page, Conray Heath. Is next, page 9. Good morning, sir.
Your Honor, on his traffic, he received a $1 bond. He also has a hold for F court.
Okay,
It's just a 72-hour hold.
thank you, sir. You were arrested for armed robbery with a firearm or deadly weapon and aggravated battery. I will appoint the public defender's office for you. Probable cause for armed robbery with a deadly weapon, even though he used initially was threatening the victim with a metal rod. A knife was found on him, so he was armed during the course of the taking.
Judge, for count 2, there's nothing indicating us that they are an identified, specified.
No,
offense.
it says Miami-Dade Housing and Community Development Employee.
It doesn't
what-
indicate, I don't think that is included. In addition, it doesn't state that they were in uniform.
I think you're right. All right. Is there a stay away order or no? I don't see one.
Judge, with respect to this case, nowhere on the save form does it list the victim's name, so I was not
Fine.
able to provide that.
Okay, so count 1, there's probable cause for armed robbery with a deadly weapon. I'm granting the state's motion for pretrial detention pending final hearing and holding you with no bond on count 1.
Judge, count 2 would just be Agbat.
Correct. I just wanted to. What's the aggravated battery?
With a deadly weapon, Judge.
Oh, is it ag battery or aggravated assault? He threatened him.
He hit them, he hit,
What's the ag battery?
Just assault, Judge.
It's aggravated assault with a deadly weapon for count 2. So
well,
count one-
I would argue that when he's forcibly removing it, he's battering him and he's got the knife and the.
It's
um,
probable
I
cause
don't-
for aggravated assault with a deadly weapon for count 2. You'll see a judge on Monday, sir. That judge will set a final hearing on the state's motion for pretrial detention. Have a good day.
Bond for count 2, Judge?
5,000 count 2.
Thank you.
Next case is Nicholas Otalvaro, page 10.
Your Honor, he has a fugitive hold for Lee County. These are added charges.
Thank you. Good morning, sir. You were arrested for conspiracy for trafficking in a controlled substance, an unlawful use of a communications device. I will appoint the public defender's office for you. I don't think it's a conspiracy. Let's see. So Mr. Otalvaro made contact with a CI offering to sell 1,000 oxycodone pills. He told the CI to meet him downtown for the transaction. This is from April 24th. So he sold was it 100 oxycodone pills? There's probable cause for the charge. What bond do you want on that? $100,000.
Judge,
Curious, it's mandatory for this one. Sturgis. The 100 pills. I guess $50,000 bond for count 1. And count 2, unlawful use of a communications device is $2,500. Have a nice day, sir.
All right, let's talk about that. Judge Mindy Glazer ran a tight ship in this morning calendar, and it was everything we've come to expect: measured, composed, and brisk with no nonsense. Starting off with Mr. Aguilar, we had what could shape up to be a complicated case. His attorney floated a self-defense argument, citing a firearm allegedly seen in the victim's vehicle and prior incidents suggesting the victim may have been armed before. But the state countered quickly, pointing out that no gun was recovered at the scene on the day in question, and the video footage apparently doesn't back the defense up. Judge Glazer acknowledged probable cause and granted the state's motion for pretrial detention. No drama, no long speech, just steady judicial gear shifting. Mr. Aguilar will remain in custody pending a full hearing. From there, the courtroom moved swiftly through the docket. One gentleman facing a habitual traffic offense. Mr. Japa got a fair but stern warning about what would happen if he got behind the wheel again without a valid license. Judge Glazer offered him pretrial release but made it crystal clear. One more slip and he's staying in jail. No theatrics, just clear boundaries. Mr. Neely came next with possession-related charges. The probable cause was established quickly, and the judge issued a reasonable bond with pretrial services, again smooth sailing. Then came a brief moment of linguistic choreography when a Spanish interpreter was called in from Mr. Veolanga, facing aggravated battery charges. Judge Glazer demonstrated patience and professionalism throughout, using the interpreter seamlessly to ensure the defendant fully understood the no-contact order, bond conditions, and the serious nature of the allegations. Next came a mix of other matters, from someone with a pending hold for another county to a defendant arrested for armed robbery who, according to the state, threatened someone with a metal rod and was later found with a knife. The judge was meticulous in parsing the statute, ultimately finding probable cause for armed robbery and aggravated assault with a deadly weapon. She granted the motion for pretrial detention, holding the defendant with no bond for the primary charge and issuing a $5,000 bond on the secondary. Judge Glazer's tone never shifted, cool, neutral, and unshaken even as the allegations varied. And wait, by the time we hit Nicholas Otalvaro's hearing linked to an alleged offer to sell 1,000 Oxycodone pills, the judge confirmed probable cause and issued the standard bond structure. No flourishes, just facts. Throughout the hearing, Judge Glazer kept the courtroom on track without sacrificing fairness or clarity. The attorneys did their jobs, some a little more assertive than others, but no one was visibly flustered. Even when tensions could have spiked, like with the firearm claims or bond disputes, everything remained on the rails. Overall, the atmosphere stayed composed, if a bit weary by the end, but the judge's calm cadence kept things moving. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I rate every one.